Advocate Malesela Teffo, perhaps better known as a former defense lawyer in the Senzo Meyiwa murder trial, is back in the spotlight. The High Court in Pretoria has found him in contempt of court for disobeying a strike-off order. Last week, the court slapped him with a 12-month suspended sentence with strict restrictions. He's also been ordered to pay the Legal Practice Council's legal costs. The council pressed for Teffo's removal from the role of advocate and brought that matter before the court. Let's unpack the implications, bring in the council's director in Gauteng, Ignatius Briel, who joins us via our audio link this morning. Great to have you on the program, Ignatius. Thanks very much indeed for your time. I'm hoping we're able to take a couple of steps back for the benefit of our viewer. Why was Malesela Teffo granted this, I beg your pardon, how was he found to have been in contempt of court?
So this matter has a long history, and I think the gist of it is his general behavior towards the court. After we had previously applied to court to have him struck from the role, he persisted in appearing in court as if he is still a practicing advocate. He refuses to cooperate with us by providing us with the necessary files and documents that we need to finalize the matter. And generally, his behavior towards court is just simply unacceptable.
And my understanding is that you received complaints about him from as far back as 2021. What's the nature of those complaints? Is it around the same issue, essentially his demeanor in court?
It is that, but then also in terms of the Legal Practice Act as it is at the moment, there's a distinction between advocates who are supposed to accept instructions only from attorneys and then advocates who may accept instructions directly from the public. Now, Advocate Teffo was not what we call a trust advocate, meaning he could accept instructions directly from the public. But he did so, and he also accepted money for the work that was done. So that was a big part of the complaints also, beyond the behavior in court.
Is that the case also in the Senzo Meyiwa murder trial? Was that him accepting this instruction directly from clients? Because I imagine someone as embattled as this shouldn't come anywhere near prominent cases like these.
I'm not 100% sure in the Meyiwa trial whether he had instructions from attorneys or directly, but you're quite right. I mean, somebody like that should not be partaking in any proceedings in court.
Yeah. There are a couple of people who've spoken about Malesela Teffo's behavior in court, and part of what's been written about is perhaps the danger here is that you're finding more and more legal practitioners performing for the spectacle of cameras inside court. How worried are you as a legal practice counsel about that?
I think it is a very worrying situation. I think the impression that it creates with young, newly admitted attorneys is that there's fame to be had. And the role of an advocate and attorney is definitely not to seek fame. It's there to assist the public and to assist the court in the execution of justice. Yeah.
And the other concern, of course, is the dent that this leaves on the profession itself.
Absolutely. And I think, we've seen a lot of the colleagues expressing their dissatisfaction with this nature of behavior. And, unfortunately, it's becoming more commonplace. And it leaves the profession in disrepute.
What are the solutions then, Ignatius? Because on the one hand, you can't remove those cameras from court if, in fact, this is a major issue because of the public interest that many of these prominent cases hold. And on the other, we can't have the status quo continue because of what we've just spoken about.
So it's a difficult situation. And I think, it starts with the colleagues actually taking each other by the hand and saying, listen, this behavior is simply not acceptable. But then also for the unacceptable behavior to be reported to us as soon as possible so that we may then action and, where necessary, take the steps to suspend or strike the practitioner.
Yeah. Speaking about those next steps, what happens if Malesela Teffo takes up another case in any kind of form in the context where this order is in place?
So look, that's quite simple. I mean, the current order was suspended, allowing him an opportunity to provide us with the information that we need, but then also to stop him from acting the way that he has been acting. So in any of those instances where he does not comply fully with the court order, we will be back to court in a blink of an eye, and the court order will be enforced for his 12-month imprisonment.
Sure. Is that where the sanction ends? After the 12 months, for example, would he essentially be allowed to practice again?
No. No, keep in mind that he has been struck from the role.
Right.
So he's not allowed to practice anymore.
Right, okay, I think that's very important. And what kind of, well, I suppose this is an unfair question, but would the people who elicit his services be in any way complicit in a crime, if you know what I mean, especially if it can be proven that they're aware that he shouldn't be, in fact, be practicing in court?
Look, like you said, I think it's a difficult question. One would have to look at the circumstances. But I think what we need to accept is that, people are duped into thinking that they're dealing with somebody who is ethical and bona fides. So it would be difficult to show that a client who made use of his services is guilty of a crime.
Right. And, speaking about, whether or not he is an ethical person, I think there's been a lot of commentary at the moment about people who are masquerading as, people who are qualified in what they do. In a completely unrelated case, there's a lot of conversation around Matthew Lani, who's been masquerading as a medical doctor for quite some time, going as far as to give medical advice. Is that a concern you have around Malesela Teffo? Are you raising any questions about his qualifications, given, I suppose, just this spectacular fall from grace, some people might say?
At this stage, no. I think at the time that he was admitted, the due diligence would have been done to ensure that he has the proper qualifications. Otherwise, he would not have been admitted.
How widespread are you finding this issue to be? People who, unfortunately, you have to advocate for them to be struck off the roll because of their behavior in court?
Look, it appears to be a lot of matters, but if you look at it in the context of the number of practitioners in the country, it is still only a handful. I think at the moment there's, let's say, roughly in the region of about 200 matters nationwide where we might be looking at suspension or striking. So given the extent of the number of practitioners, it's not that many. But I think, even just one, especially where it's serious instances of misappropriation of trust funds or, misbehaving in court, as we've got in this case, even one matter is too many.
Absolutely. Ignatius Briel, thanks very much indeed for speaking to us. Appreciate your time on Newzroom Afrika this morning.